Just a couple of weeks ago, I got a check, a settlement check from Snapchat. I think it was like $16 or something like that. And then like a few weeks before that, I got a settlement check from like Equifax or something for like $5. I totally forgot about that one. But even before that, gosh, I think I got like close to $400 from Facebook. Now, the Equifax was different. That was an identity theft type thing. A whole bunch of people impacted by that, if you recall. But the Facebook and the Snapchat settlements were because of Illinois' unique and a lot of people seeing as very strict Biometric Information Privacy Act law. What is the Biometric Information Privacy Act? Well, look at my face, all right? It's got unique identifiers. My pupils are a certain distance apart. My nose is a certain length. My lips are a certain distance apart. My ears even. These are all individual markers that's very similar to your thumbprint. It's unique to you. And years ago, the Illinois legislature, for whatever prescient insight they had, they wanted to limit a company's ability to gather this type of information, be it your face scan, be it your fingerprint, and to be able to use that information without your permission. So they approved the Biometric Information Privacy Act. And under that act, you've had Google having to settle for substantial amounts of money, Facebook having to settle for substantial amounts of money, Snapchat, and even most recently a case involving White Castle, which had questions about White Castle using their employees' fingerprints to clock in and out of work. But there's some questions being raised about how severe this law is, especially when you're talking hundreds of millions of dollars in settlements from social media companies to pay out wholesale to people across the state of Illinois. And what about employers like White Castle? How are they impacted by this? And I think there was a separate case about Six Flags years ago. One individual was suing over having to use their thumbprints and didn't get proper permission. But what's going on here? To talk a bit more about this is Phil Melin. He is the executive director of Citizens Against Lawsuit Abuse, Illinois. And Phil, thanks for taking time with us. We've got a whole bunch of other business groups that are going to be taken to a podium at the State House, the Chicago Chamber of Commerce. You've also got the Manufacturers Association involved there, several other groups involved. They're going to be talking about BIPA, as it's called. What is BIPA? Why is it bad for business, and what needs to change about it? Good morning.
Good morning, Greg. Thanks for having me on. And man, you did a great job of describing BIPA. As you said, it's a law designed for a very important purpose, to protect people's biometric information, their face scans, their fingerprints. And, this is relatively new technology, and it's important to protect people's privacy. But, I think when we look at laws and legislation, it's really important not to just stop looking when you look at the intent of the law, but to look about how the law is actually being applied, and to make sure that there's not unintended negative consequences. And in the case of this particular law, the BIPA law, the unintended consequences are potentially extraordinarily devastating, not only for the big social media companies that you talked about, but also for thousands of small businesses that have been sued under BIPA in Illinois. And and with these latest lawsuits that you mentioned, we can talk about that. The potential, the magnitude of damages is potentially catastrophic. And so it's a big deal, and I'm glad that you're taking the time to talk about it and let your listeners know about it.
And we've talked about it in some detail. I remember when it passed years ago. Gosh, it was like 2008 or something like that. And there was a lot of concern about the technology back then, kind of in its infancy, right? And then you had people's Google Photos automatically being cataloged into folders with their friends' faces, and they didn't realize I didn't tag my friend in that, and it was automatically doing it. And then it just kind of started in this natural progression of people realizing, well, wait a second, this is seemingly technology that's increasing more and more. It's becoming easier to come across and also easier to catalog things. And listen, the White Castle case out of the Illinois Supreme Court, you had the dissent of that case where the majority supported keeping BIPA in place, but the dissent in the case recognized White Castle, just for, scanning their employees' fingerprints to clock in and out, even for lunches and whatnot, that could total what, like $17 billion?
Yeah, that's with a B. 17 billion. That's a lot of hamburgers, Yeah, the interesting thing about the White Castle case, and it was a massive expansion of the BIPA. And I think the dissenting obviously had the better reasoning in this case. It's narrowly decided, but what happens is, so imagine if you work at White Castle and you check in with your fingerprint. Now, what White Castle is trying to say is that, okay, that's one collection. Even though you might check in the morning, and then you check in at lunch, and then you check in, when you clock out. The plaintiffs, the trial attorneys, were saying that that's 3 check-ins, and a violation for each one of those, which is, I agree with the dissent in that opinion. That's pretty ridiculous when you think about, what they're trying to protect. It's not like they were getting different fingerprints each time or whatever. They're getting the same fingerprint. So it's one collection, and the privacy interest that's being protected there is really just a fingerprint, not each collection of it. But the majority said it. So that turned what could be a damages in that case to maybe maximum of $95 million, which is an extraordinary sum, certainly enough to make sure that people are complying with BIPA, but it turned it from a 95 million potential damages to 17 billion. Like, I mean, it's hard to even quantify and think about what $17 billion looks like. Certainly White Castle would not be in a position, would have to go bankrupt to satisfy a judgment like that. So
it's pretty incredible. We're talking with the executive director of Citizens Against Lawsuit Abuse Illinois, Phil Melin. What's the middle ground here? Obviously, we want to make sure people don't have their face cataloged without their permission. We don't want people to have their fingerprints cataloged without their permission. What's the happy medium here?
Yeah, 100%. I mean, we got to protect people's biometric information, as we move forward. But that BIPA law was written in 2008 when the technology was really early, and it's just sort of out of date, and so it needs an update. And that's what the coalition of industry groups that are meeting this morning are going to be talking about. And they're not looking to get rid of BIPA. They're not just saying, hey, let's go to the Wild West and just let any company collect anything they want from their employees without permission. What they're saying is they're looking for, calling on the legislator to do some reforms. And the good news is that there has been some bipartisan action already. But the majority in that White Castle case that just came out a week or so ago actually encouraged the legislator to clarify their position and to make some corrections to BIPA. And so there's been some bipartisan response to that already. A gentleman named Bill Cunningham in the Senate and Jeff Kiker, Bill Cunningham's a Democrat, Jeff Kiker's a Republican. They introduced a bill that would make some changes to the BIPA law. And particularly, I think the most important would be to change that White Castle ruling to where it would just be one collection, the fingerprint situation, like that described before. It would be considered one collection of the fingerprint, not multiple collections, so that you would have it. They also they wanted to exempt from BIPA certain situations that were kind of sensitive security issues are involved, and there's a really important purpose for collecting information, as long as that information is treated appropriately. And then one thing I wanted to say also, Greg, is that this BIPA stuff doesn't really. It's kind of a harmless crime. In fact, that the defendant pays the penalty, regardless if they're not selling the data. They're not giving the data away. They're not careless with the data. It's just a matter of they're not giving the notice, And so that these employees of White Castle, their personal data, there's no allegation that their personal data was sold to somebody or being used in a nefarious way. It's sort of a statutory violation, not a harm violation. So that's sort of an important point to do. So anyway, the good thing is that there's a lot of legislation coming out, and we really hope that that the industry groups are successful today, and that their common sense, reasonable, bipartisan legislators in Springfield understand that we can protect people's privacy without handing massive settlements. And one last thing, you mentioned that you got that Facebook lawsuit. You got $345. The attorneys,
it was close to like $400. Yeah, they got
$97.5 million. So, when you start to think about whose interests are being served here, that discrepancies between the judgment and the attorney's fees are pretty interesting, I think, and something maybe that the legislature should take a look at as well.
So you'd mentioned Jeff Kiker. I've got his two bills pulled up here. You've got House Bill 3119 and also House Bill 2335. Those actually have some hearings scheduled for next week, one in the Judiciary Criminal Committee and another in the Judiciary Civil Committee. You mentioned another lawmaker. Again, who else in a bipartisan approach here?
Yeah, the Senator Bill Cunningham, William Cunningham, I think he goes by. He introduced, I think, from what I can tell, identical, if not very similar, bill to Jeff Kiker. He introduced them in the Senate. So,
so we've got Senate Bill 1506 and Senate Bill 1511, just for those who are keeping track. And Cunningham's rather significant because he's in leadership with the Democrats at the State House, so we'll see just how much that goes through. He's the Senate President pro temp, so interesting to see that. And again, you got a bipartisan approach here. So apparently there is an effort to try to bring about some changes, and we'll hear a lot more about this in the hours to come, in the days ahead, as the legislature has a mid-May deadline to finish things up. So greatly appreciate it. Phil Melin, he is the executive director of the Illinois chapter for Citizens Against Lawsuit Abuse. Greatly appreciate it. We'll talk again soon, okay?
Thanks, Greg. Appreciate the time.
Yep. Springfield's Morning News, late for news, 8:35 now on WMAY.
92.7 WMAY.
Here are